Students, under the kslu examination, the question with regard to the registration of firms is at most guarantee 1. Here, with regard to the registration of firms, normally the question will be like this. Discuss the registration of firms and consequences or effect of non-registration of firms with the help of case laws. So in this way, the question will come in the Karnataka State Law University examination. Here, what are all the things we have to write with regard to this question? Here we have to write something with regard to the registration of firms. Here, from section 56 to 71, we can find the provisions with regard to the registration of firms. So here, we have to write the procedure for registration of firms, and we have to highlight with regard to is there any time limit is there with regard to the registration of firms, and we have to write with regard to whether changes can be made with regard to the particulars of registration which has already been registered. So we have to write all these things, and besides we have to mention with regard to what are all the penal clauses for false particulars has been given before the register of firms while registration. And we have to highlight with regard to the rules of evidence and evidentiary value of the documents with regard to the which has been registered before the register of firms. So these are all the aspects concerning to the register of firms. Then we have to write with regard to the effects of non-registration, or we can say it may be advantages of registration or disadvantages of the non-registration. So it can be divided under 3 headings. That is, no suit can be filed by a partner against the firm or the partners. So under which we have to decide the aspects concerning with regard to the filing of the suits by a partner who is under the unregistered firm, whether he can file the suit against the firm or against his partners. And also, no suit by firm against the third parties. That means, whether against the third parties, a suit can be filed by the unregistered firm. And besides this one, we have to discuss the concept of the set-off and arbitration proceedings and trade mark aspect and tortious acts. So these are all the aspects we have to cover under the registration of firms with regard to with regard to the answering the question with regard to the register of firms. Let us analyze the aspects. Here under chapter 7 from section 56 to 71 deals with the registration of partnership of firms. Here the act does not make the registration of partnership firms compulsory in India, and does not this act impose any penalties for non-registration. As I was said to you, the Partnership Act does not make it compulsory for the registration of the partnership firm, and does not say with regard to any penalties can be imposed for the non-registration of the partnership firm. However, certain disabilities are provided in section 69 of the Act for unregistered firms and their partners. Here, if the firm is not registered, what are all the disabilities will follow? So with regard to that aspect, under section 69, there is a mentioning is there. So here, because of the disabilities only, the majority of the partnership firms, they will get registered voluntarily. So let us know something with regard to the procedure for registration of the partnership firms. Here the procedure for registration is very simple, and the disadvantages of non-registration are so great that generally the partners of a firm would like to get the firm registered. So this is what the beauty of the Partnership Act. Here, let us see what is the procedure has to be followed, whether it is a cumbersome procedure is there, whether it is a simple in its nature. Here, under section 58 and 59, which deal with regard to the procedure for the registration of a firm. The registration of a firm may be affected by submitting to the Register of Firms a statement in the prescribed form and accompanied by the prescribed fee. So, what is the procedure is that just with regard to the getting registered registration of firm, a statement has to be filed in the prescribed form or prescribed format. There will be some prescribed format will be maintained by the office of the Register of Firms. So, under which the statement has to be signed by the partners and it has to be accompanied by the some prescribed fees. The Register of Firms are appointed by the state government. A state government is also to define the areas within which the registrars shall exercise their powers and perform their duties. So this is the aspect, that is constitution of the Register of Firms, how it can be made. So this can be made by the state government. Here the application for registration has to be made in the prescribed format and the same has to be accompanied by the prescribed fee. That means some fee has to be paid for the registration. The state government has been authorized to make rules prescribing the fee, but that shall not exceed the maximum fees specified in the Schedule 1. That means here Schedule 1 plays a vital role with regard to the registration of the firm. Here there will be some fees will also be given under that schedule. So what are all the other requirement has to be stated in the statement before the Register of Firms file registration, or the application must state the following things. That means what are all the necessary things should be submitted. Information has to be submitted before the Register of Firms. Here the firm's name should be there and place or principal place of business of the firm should be mentioned. So the name of the firm has to be mentioned and where the business of the firm, that is principal place of the business of the firm, will be undertaken, and the names of any other places where the firm carries on business, that is principal place of the business has to be mentioned, and other areas where the business will take place. So those aspect also has to be submitted in the information, and the date when each partner has joined the firm, and the names in full and permanent address of the partners, and the duration of the firm. So these are all very much important. That means duration of the firm has to be mentioned, and the information with regard to the partners when they have joined the firm has to be mentioned, because as you know, the partners, certain partners, they will join later. So with regard to their disability or ability, which will depend upon this aspect, because at the time of joining of the time of registration, certain partners will be there. Later, some partners may got joined to this partnership firm, but their their aspects has not been mentioned. Then they will suffer the disability. So, what are the things which has to be seen here? The statement shall be signed by all the partners, by their agents, specifically authorized in this below. That means here the statement has to be producible before the Register of Firms, and these statements has to be signed by either the partners or their agents authorized on behalf of the partner. Here each person signing the statement shall also verify it in the manner prescribed. That means here the statement proves to be very much a evidentiary value in its nature, because the public in large they will depend upon the statements produced by the partners before the register of firms. That's why they have to give the correct and factual information. A firm may got registered at any time after the creation of partnership. That means a firm, there is no necessary that the firm should be registered within this time or that time. The duration has not been mentioned in the Partnership Act. It is not necessary that it should be registered at the time of its formation. Moreover, the Act does not lay down any time limit within which the firm should be registered. So this is the very important thing, that there is no time limit is there and there is no compulsion is there. Therefore, there is no period of limitation either for the original registration or recording of the subsequent changes as contemplated in Section 63 of the Act. So, this has been said under the Section 63 of the Partnership Act, Indian Partnership Act. Here, thus the concept of any limitation period or that of reasonable time cannot be introduced either for original registration or for the subsequent changes in a firm. So, these are all the things we have to see with regard to the registration of the firm. Here, the registrar of the firms cannot reject an application for recording changes in the constitution of the firm on the ground of inordinate delay in submitting the application. That means the registrar of firms, he cannot reject the application on certain ground with regard to the constitution of the firm, with regard to the, suppose they have taken some time with regard to the constitution of the firm. So on that ground, with regard to the delay aspect, the registrar of firms cannot reject the application from not getting registered of the partnership firm. If a firm remains unregistered, the firm and its partners would suffer from the disabilities mentioned in the Section 69. So with regard to these aspects, what are the disabilities? Will the unregistered firm and its members means the partners will suffer, has been given under the Section 69. If the firm is registered but some partners have not been registered, they join after the registration of the firm. Such partners who are not registered will be subject to the disabilities mentioned in Section 69 subclass 1 and subclass 2. So that means here the disabilities will apply to the partners who have not been registered. Even though the partnership firm has been registered, certain partners they have not got registered through the partnership firm by giving the statement before the register of firms. They will suffer the disability has been which has been discussed under Section 69 subclass 1 and the subclass 2. And apart from this one, certain names should not be kept by the partnership firm. For example, crown, emperor, empress, imperial, king, queen, royal, etc. But they can get the sanction from the consent from the state government. Then they can bear this sort of the name. But if they follow this sort of the names, they will be penalized. So this is also one of the aspect we have to keep in our mind. So next aspect is penalty for furnishing the false particulars. That means the information which has been given before the register of firms through various documents should be a bona fide one, because the third parties who are dealing with the firm, they should not be misled, and correct information should be given to the registrar. So because in the interest of the third parties, the statements, the information, the documents which can be produced before the register of firms should be a bona fide one. So here, if the bona fide information has not been given, under Section 70, some penalty has been given for giving the false declaration. So here the penalty might be that the punishment may be should be imprisonment, which may extend to 3 months, or with a fine, or with both. So these are all the aspects with regard to the penalty for furnishing the false particulars. So we have seen what is the procedure has to be followed. and what are all the information has to be given, under which section which has to be given, and what are all the required aspects has to be furnished, and which name should not be kept, and what are all the penalty provisions with regard to the providing false particulars. And under section 71, the state government has got certain the powers prescribing the fees payable, statements with regard to submission of the statements, and with regard to the procedure to be followed by the registrars in case of any dispute arise, and also with regard to the filing of the documents, and with regard to the inspection of the documents, with regard to the all these aspects, the state government can prescribe the rules to be followed with regard to the filing the documents, inspection of the documents, or with regard to the furnishing the information with regard to fees payable and statement to be submitted, which has been discussed under section 71. And further changes and alteration can also be made once the partnership firm has been registered. Subsequently, the changes can also be allowed from which has been mentioned, which has been discussed from section 60 to 65. So there are certain aspects as are there. So which are all the aspects, which are all the corrections, which are all the alterations can be made in the original statement. So the partnership firm, it has got every liberty with regard to the making the alteration in the firm name and principal place of business. What happens? Certain times the partnership firm name may not be lucky one, because the partnership firm members or partners, they don't believe that they believe that they don't the name while they getting registered the partnership firm, which is not a lucky one. So they can change the partnership firm name, and they can they can go start the business in with regard to the and in any other place, but they can they can bring this information by way of alteration in the original information which has been given to the register of firms. And there can be informations can be made with regard to the change of timings with regard to the branches, or that is closing and opening of the branches. That means with regard to the closing and opening of the branches, it may be with regard to the with regard to the certain times, or with regard to the places also. When there is a closing or opening of the branches of an already existing firm, any partner or agent of the firm may send intimation thereof to the registrar, who shall then make necessary changes in the register of firms. That is, they can open new branches, they can close the old branches. So whatever it may be, the partnership firm which has got the liberty to make the information which has already been given before the register of firms by way of statements, depending upon the changes in the course of their business. And also changes in names and address of the partners can also be made, because as you know that the partners they may not reside in there is no compulsion that they can reside in a common place. They can they can change their names also, but those information they get it changed before the register of firms. So that is that will be a better one from looking into the relation with regard to third parties. So likewise, changes in the constitution of the firm or on the dissolution of the firm. Here, changes in the constitution of the firm may occur either on the introduction of a partner to the firm. That means how the constitution of the firm will be changed, because some new partner may come up, or when a partner ceases to be a partner by retirement, expulsion, insolvency, or death. So in this event, such changes can be made, such in the constitution of the firm or dissolution of firm. It has to be mentioned with regard to the before the register of firms, like registration of firm. The notice of the changes in the constitution of firm or dissolution of firm is not, however, compulsory. But here, in the case of retirement or expulsion of a partner or in the dissolution of firm, public notice of such retirement, expulsion or dissolution has to be given. That means, other than making the changes in the already statement or with regard to the admission of a new partner or retirement of a partner, or is a partner he can be expelled, and some partner might have died. So such information can be make note of. And with regard to if any partner get retires, such aspect also has to be given to the register of firms. However, it is not necessary because of the consequences for not intimating the register of firms with regard to the retirement of a or expulsion of a partner is very much important. Otherwise, the liability of such partner will continue. So with regard to this one, I have made a video with regard to the public notice. It is like a duty of the retiring partner as well as a partnership firm to give the public notice. It has to be intimated to the register of firms. Otherwise, the liability will continue with regard to the partner who retires without giving the public notice. And if he is not given the partnership firm also, it is not intimated for the partnership firm also, the liability will continue. So these are all the things which it has to be written in our answer. Likewise, amendment of register by the order of court. That means under section 65, under any dispute, if any matter has been arisen with regard to the registration of registration of firm, the court may direct the register of firms to make any changes with regard to the aspects with regard to which has been registered before the register of firms. So here the document is also very much what are all the documents which has been furnished before the register of firms is here the public they can get the copies. So here the inspection of documents, grant of copies with regard to all these things, there are the rules has been mentioned under the section 66 and 67, and the fee can also be levied with regard to with regard to inspection of any document, and also giving the copies with regard to the documents which should be registered before the register of firms, which has been mentioned under the schedule 1. So with regard to this one, the state government make any changes with regard to the imposing the fee for giving the copies of the documents, or with regard to the inspection of the document. And while discussing with regard to the evidentiary value of the increase in the register of firms under section 88, it holds the evidentiary value. What are all the documents filed with the registrar on the basis of which he prepares his record on register of firms shall be conclusive proof of the facts. Here under the Evidence Act, the aspect of conclusive evidence is very much important. Here whatever the information the register of firm has he has taken from the while registering the firms, that will held as the conclusive proof of the facts. So that has been discussed under the section 68. So these are all the things we have to write with regard to the registration of the firms. That means these are all the other aspects. Even though these are all the aspects which are coexisting with regard to the aspect of the registration of the partnership firm. Let us move to what is the effect of non-registration. That means what are all the effects or the consequences of the non-registration. We can say this may be advantages of the registration, or the disadvantages for the non-registration. So under section 69, which has been provided that no suit to enforce a right arising from a contract or conferred by this act shall be instituted in any court by or on behalf of any person suing as a partner in firm against the firm, or any person alleged to be or have to be a partner in the firm unless the firm is registered and the person suing is or has been shown in the register of firms as a partner in the firm. That is, even though this definition seems to be very much lengthy one, it says the aspect that what are all the consequences will follow for the effect of non-registration. That is, no suit by a partner which can be filed against the firm or the partners. That is, a partner of an unregistered firm cannot sue his present or past partners. A partner of an unregistered firm cannot sue his present or past partners for enforcing a right under the contract under the Partnership Act. So this we can say in this way. That means here, no suit to enforce a right arising from a contract shall be instituted in any court by or behalf of a firm against any third party unless the firm is registered. So this is what I have said to you. But with regard to this aspect, no suit to enforce a right arising from a contract or confirmed by this act shall be constituted in any court or by on behalf of the any person suing as a partner in a firm against the firm or any person alleged to be or have to be being a partner of the firm. That means these under section 69. We can see the mainly two things. That is, first one is no suit by a partner against the firm or partners, and another is no suit by firm against the third parties. So these two things we can see under section 69. So here it may be noted that the Partnership Act neither makes the registration of firm compulsory nor does it impose any penalties for non-registration. However, it provides certain disabilities for unregistered firm, and the partners of a such firm are the partners whose names have not been shown as registered partners, though the firm is registered. That means, what are the consequences will follow if the names of the certain partners has been not registered, if the partnership firm itself is not registered. So those things we have to see under 69 sub plus 1, 69 sub plus 2 and 69 sub plus 3. So these things we can see under 69 sub plus 1, which provides that no suit can be instituted to enforce rights arising from a contract or conferred by the Partnership Act by any partner against his co-partners or against the firm. This I have said to you now only. Similarly, according to section 69 clause 2, sub clause 2, no suit can be instituted to enforce any right arising from a contract by an unregistered firm against any third party. So this is very simple with regard to the section 9 sub clause 1 and 69 sub clause 2. One is that no suit can be instituted to enforce right arising from a contract or conferred by the Partnership Act by any partner against his co-partners or against the firm. And 69 to sub clause 2, no suit can be filed against the third party. Under subsection 3, which provides that the disability mentioned in the subsection 1 and subsection 2 shall also apply to claim of set-off or other proceedings to enforce a right arising from a contract. So this is also very much important. So here what happens, here an unregistered firm or any other partner, they cannot claim the set-off. I know what is meant by set-off. There is some amount due to the partnership firm from third person, and partnership firm also has to pay certain money to the third person. That means both the parties they have got certain amounts in due. Here, if the firm is not registered, the partnership firm cannot ask for its due amount from the third party, even though the third party has kept the certain due amount which is to be paid to the partnership firm. But instead of that one, the partnership firm has to pay the amount to the third party. For example, if the unregistered firm files a case to recover rupees 5,000 from a debtor X, we can think some debtor X is there, and if the firm has to pay rupees 10,000 to the same debtor, that is X, then the firm cannot adjust the debt by paying only rupees 5,000. So this is this aspect can be called as the set-off. So that has been provided under subclass 3. So this is also a disability. So here we have to discuss this aspect under these headings. So here one more aspect have been added with regard to suit only by an authorized person. So here while writing our answers, we have to highlight certain case laws. Here case laws are very much important with regard to the with regard to the drawing the principles which has been established under law, because as you know there are the provisions will be there with regard to the registration of firms or non-registration of the firms, but the courts by what happens, the courts they will develop certain principles. So it is our utmost, being a law student, it is our duty to highlight those case laws. So here with regard to the disabilities, I have segregated the three aspects. So here I am basing on the book of written by Dr. R.K. Bangia. So it is very beautiful book. So in which it has been given, which has been discussed under three headings. That is suits between the partners and the firm, and the suits only by authorized person, and the suits between the firm and the third parties. So under these three headings, the consequences of non-registration of the firm and with regard to the filing the suits has been discussed in length. Here, effect of non-registration: no suit to enforce a right arising from a contract confirmed by this act shall be instituted any court or by on behalf of any person suing as a partner in a firm against the firm, or any person alleged to be or have to be in a partner in the firm, unless the firm is registered and the person suing is or has been shown in the register of firms as a partner in the firm. So these are all the has been mentioned under subclass 1, and subclass 2: no suit to enforce his right arising from a contract shall be instituted any court by or on behalf of a firm against any third party, unless the firm is registered and the person suing are to have to be shown in the register of firms as a partners of the firm. Here what happens, here it should be noted that Partnership Act neither makes the registration of firm, I think this is repeated. So here up to this one it has been repeated. Here the suits between the partners and the firm. Here what has been said, according to section 16 as a plus 1, no suit to enforce a right arising from a contract or conferred by the partnership can be instituted in a court unless the following two requirements are satisfied. That means, which are all the two requirements which incapacitates a partner to file a suit is that the partnership firm, if it is not registered and the partners filing the suit have been shown in the register of firm is not there. That means these two things should be there to file the suit. That means the partnership firm should be registered and the partners filing the suit has been, their names has been mentioned in the register of firms. If their names does not found place in the register of firms, then also they will suffer from the disability. Thus, there should be registration of firm and the person suing are have been shown in the register of firms as partners in the firm. So their names has to be shown in the register of firms. The firm is registered when the entry of the statement is recorded in the register of firms and the statement is filed by the registrar as provided under section 59. So this has been how to enter the names, how to file the statements which has been given under section 59. So this provision bars a suit between the partners or between the partners and the firm if the firm is unregistered. So which bars a suit between the partners if it is not registered, which bars the partners or between the partners for with regard to the filing the case. Even if the firm is registered, only such partners can sue whose name appear in the register of firms. This is very much important. That means whose names has been appeared in the register of firms, they can only file the suit or the case. Therefore, if some partners join after the firm with certain other partners which has been already been registered, unless the newly introduced partners also has not been shown in the register of firms. That is, there the partners may get joined later also. But here, when they can join and whether they can enter their name, these are all immaterial. So, in order to get the advantages of the registration of firms, they should get their name register. Their name should be found in the register of the firms. So this is the aspect. This is the first aspect. Next next aspect is suits only by an authorized person. That means here, what about the person who has been authorized to file the suit? What we are under the eye of law. So this has been discussed under the case law of Popular Automobiles versus G.K. Cheney. Here, the suit was filed on behalf of the firm. The plaint was signed by the manager of the firm. No power of attorney was given to him by the firm to verify and sign plaint on behalf of the firm, nor his name appeared in the register of firms as a partner. That means these are all the disabilities. So here, when the name of the manager of the firm has not been mentioned before the register of firms, and when there is no due authorization, then no suit can be filed, even though he has been authorized to file the suit. But whether this defect can be rectified means, so this defect cannot be rectified. So such defect cannot be cured by the subsequent incorporation of verification and signatures by a partner. So this aspect has been discussed under the case law of Popular Automobile versus G.K. Cheney. So this aspect we have to see, and with regard to this one, the AP and Madras High Court has also taken the stand. So it may be submitted that above said decisions of the AP and Madras High Court, which consider the plaint which was invalid to be validated after registration, do not seem to be convincing. If there is a patent defect in the plaint known to the parties on account of the non-compliance of the statutory provision. So whatever it may be, the subsequent the curing cannot be provided if there is no if the partnership firm is not registered. The suit should be dismissed even if there is hardship to the plaintiff insofar as he will have to file a fresh suit for the same cause of action. So this aspect we have to appreciate with the help of case laws. And let us see with regard to the aspect of suits between the firm and the third parties. According to section 69 subclass 2, the firm is unregistered. No suit to enforce a right arising from a contract can be instituted by the firm or its partners against the third party. Subsection 2 also requires two conditions to be followed by before a suit can be instituted against a third party. So here we are discussing with regard to the whether suit can be instituted against the third parties if the firm is unregistered. Here the first condition is, in order to file a suit against the third person, is the firm must be registered firm. The person suing must be shown in the register of firms as partners of the firm. This is very compulsory one. And here there is a difference with regard to the registration of the firm and registration of the partnership deed also. Here in the case of Muthu Kumar Swamy versus Kumar Textile, it has been held that provisions contained in section in subclass 2 is mandatory, and registration of the firm is a condition precedent to its right to institute a suit. Even if the defendant does not raise an objection to provision contained in section 69, cannot be floated. That means here in Muthu Kumar Swamy versus Kumar Textiles, it has been held that even though there is a provision for the with regard to the there is a the consequences with regard to the of non-registration of the firm, here it is there. Even though the defendant he fails to highlight before the court of law that certain partnership firm is not registered, but it is a material fact that the certain partnership firm has not been registered, it cannot claim the advantages. The trial court is to find out its plaintiff firm is registered for that purpose. The court should enable the parties to adduce evidence to that effect. That means the court is very much particular with regard to that aspect, with regard to the registration of the aspect. As I have told you, with regard to the registration of the partnership deed, which is not compulsory. Here we should not get confused with regard to the registration of the partnership firm and registration of the partnership deed. Here registration of the partnership firm is made, it can claim the advantages. But if the registration of partnership deed is not been registered, then there will not be much significant consequences will not be there. So this has been this has also been, we can see here, registration of partnership deed under section 69 clause 2 says the following requirements for maintaining a suit against the third party: that a firm filing the suit must be registered firm, and the person suing in the name of the firm are shown as partners in the register of firm. Here, thus under section 69 clause 2, thus does not require that the partnership deed must also be registered to enable the firm to file a suit against the third party. So this aspect we have to see that here under 69 subclause 2, it is not concerning with regard to the partnership deed, but it is concerning with regard to the partnership firm. But normally what we will think, that is partnership firm before the register of the firms, if they obtain, if they give that if they give that if statement is been registered, it is well and good. For statement, the format will be there. For partners has to be appear, they have to give the statement. But they do not have to get this partnership deed has been registered. In JK Finance versus Chits Fund versus R. Surikumar, a suit filed by the plaintiff, a registered firm represented by one of its partners for the recovery of money on the basis of a promissory note from the respondents, which was dismissed by the trial court on the ground that plaintiff could not produce a registered copy of the partnership deed, which says with regard to the aspect of the registration of the partnership deed. But the Andhra Pradesh High Court held that under section 69 subclause 2, which does not require the registration of a partnership deed, but which requires the registration of the firm, which is not required with regard to registration of the partnership deed. So this has to be seen with regard to the from the clearly we have to see from the section 69 subclause 2, and there are certain other relevant aspects we have to see with regard to this with regard to this section 69. Here with regard to filing of the arbitration proceedings not barred under the section 69. That means we can say these are all the exceptions. That means here the partners they can file they can institute for the arbitration proceedings if there is any dispute among themselves. Just because the partnership firm is not registered, they should not be handicapped from instituting the arbitration proceedings among themselves with regard to the peaceful settlement of the dispute. So next aspect is with regard to the dispute concerning to the trademark. So if there is any dispute is there with regard to any trademark, so if the firm is not registered, which cannot infringes the right with regard to the trademark aspect, because it is concerning under the different enactment. It is a statutory right concerning with regard to the Trademark Act, which has been said under the Haldiram Bujwala versus Anand Kumar Deepak Kumar, that a suit for perpetual injunction to restrain the defendant from infringing the plaintiff's trade mark and passing defendant's goods as those of the plaintiff, and a claim of damages in this regard is not barred by the section 69 subclause 2. That means to say, in other words, such right does not arise out of a contract. In such a case, there is enforcement of a statutory right arising under the Trademark Act. The right does not arise out of a contract. So this is the aspect. That means here the arbitration proceedings can be issued, a suit under a trademark also can be issued, and with regard to claim of set-off or other proceedings, which I have already said that with regard to the what is the stand with regard to the set-off, with regard to claim of set-off, if it is not registered, then they can the partnership firm cannot get the benefit of set-off. So here these are all the aspects concerning with regard to the registration of the partnership firm, and the advantages and disadvantages of the non-registration of the partnership firm.